Okay, it looks like the attendees entering have started to level off a little bit. So I think we can get started now. Before we kick the event into high gear, I'd like to introduce the Dean of NYU Law School, Trevor Morrison, to welcome everyone with some remarks.
Thank you. Good afternoon, everyone. And yes, indeed, welcome to this event. It's my pleasure to welcome you to this commemoration of the life and work of Judge Jack Weinstein. I'm really grateful to our Center on Civil Justice here at NYU Law for convening this event and for assembling a truly wonderful array of speakers from private practice, from academia, and from the judiciary. Thank you to all of our speakers for being part of this event. Judge Weinstein was, as we all know, a true titan in the law and made an immense impact in the area of civil justice in particular. And so it's fitting that our Center on Civil Justice would be organizing this event today. The center, since its inception in 2014, has served as a home to leading scholars in the fields of civil procedure and complex litigation. It serves as a network for practitioners and judges and other experts who share an interest in improving the system of civil justice, the civil litigation system in particular. I want to thank Peter Zimroth, the director of the center, as well as the faculty directors, Sam Issacharoff, Arthur Miller, Jeff Miller, and Troy McKenzie, most of whom are here today. Thank you for being part of today's event and for your leadership of the center. And with that, let me turn things over to Peter. Peter.
Thank you. Thank you, Trevor. I want to welcome everybody who's joined us, and thank you for coming. My name is Peter Zimroth, and as Trevor said, I am the director of the Center on Civil Justice here at NYU Law School. The center is dedicated to the study of the civil justice system in the United States and how it can fulfill its purposes. Our board of advisors includes some of the most distinguished judges, lawyers, scholars in the country, with roughly equal number of plaintiffs and defendants lawyers. Several of our board members will be participating in today's event. As all of you know, Jack Weinstein passed away on June 15th this year, just short of his 100th birthday. He had remained an active judge until his death and had not taken senior status until he was 98 years old. Judge Weinstein was a titan of the legal profession, and his impact has been felt on countless areas of the law. But more importantly, Judge Weinstein touched the lives of so many people during his long life, and we are privileged to be able to honor him today. Today's event consists of two panels. Each panel will feature a number of Judge Weinstein's friends and colleagues who will take turns sharing their memories of him. The first panel focuses on Judge Weinstein's life as a judge. Panelists will discuss his judicial philosophy, his role in clearing the court's habeas docket, his judicial management, especially of complex cases, and his interaction with legal academia. The second panel will focus on Judge Weinstein's impact on complex litigation. It will cover his philosophy on complex litigation, including his views on the relationship between the executive, legislature, and judiciary, and it will explore the role of empathy, even in technical fields such as complex litigation. This event has been approved for 2 credits of CLE in the area of professional practice. To receive credit, you will need to submit a form that we will email each of you within 24 hours of today's event. The form will ask for codes, which will be given during each panel. Please write them down. The event will not have an official Q&A period, but you may type any questions into the Q&A box, and speakers may choose to address them either during or after the panel. Troy McKenzie, one of the center's faculty directors and a member of the center's board, will chair and participate in the first panel and will introduce his fellow panelists. Troy is a professor at NYU and a leading authority on bankruptcy and its interaction with complex litigation. Before joining NYU, Troy was a law clerk to Judge Pierre Laval of the U.S. Court of Appeals and Second Circuit, and Justice John Paul Stevens of the Supreme Court of the United States, and a litigation associate of Debevoise and Plimpton. The second panel will focus on Judge Weinstein's impact on complex litigation. Sam Issacharoff, another of our faculty co-directors and member of the board, will participate and introduce his fellow panelists. Sam is the Bonnie and Richard Reese Professor of Constitutional Law at NYU and one of the world's leading experts in complex litigation. Before coming to NYU to teach, Sam taught at Columbia and the University of Texas. Thank you all for coming, and we look forward to a very stimulating 2 hours. We really appreciate your being here to honor Judge Weinstein. And just remember, we will be sending an email to each of you tomorrow with a form. If you would like CLE credits, please remember to complete the form. Turn the floor over to Troy.
Thank you very much, Peter. As Peter said, we're going to talk for about 50 or so minutes on this panel, hearing from those who were colleagues, friends, and other collaborators with Judge Weinstein over the years. I will introduce them and then give my own reminiscences very briefly about the judge. Denise Cote is a U.S. District Judge for the Southern District of New York. She was appointed to the bench in 1994. Before that, she worked in private practice and also in the U.S. Attorney's Office. She began her legal career as a law clerk for Judge Weinstein. Marc Falkoff is professor at Northern Illinois University. He holds a JD from Columbia and a PhD in American literature from Brandeis. He began his legal career as a law clerk on the 10th Circuit and also for Judge Weinstein. Ken Feinberg is well known, I think, to everyone as one of the leading alternative dispute resolution lawyers in the country. He served as special master of the September 11th Victim Compensation Fund and is the administrator of the BP Deepwater Horizon Disaster Victim Compensation Fund, as well as many other similar complicated roles over the years. Before starting his own firm, he was founding partner at the Washington office of Kay Scholler. John Gleeson is partner at Debevoise and Plimpton here in New York. Before joining the firm, he was a judge, colleague of Judge Weinstein's in the Eastern District of New York. Before that, he was a federal prosecutor in the Eastern District U.S. Attorney's Office. My colleague, Burt Neuborne, is the Norman Dorson Professor of Civil Liberties Emeritus and was the founding legal director of the Brennan Center for Justice here at NYU Law. Before joining the NYU faculty, Burt was a civil rights lawyer and was also the legal director of the American Civil Liberties Union. And last and certainly not least is Shira Scheindlin, who is of counsel at the Stroock and Stroock law firm. Before that, she was a judge on the U.S. District Court for the Southern District of New York. Before joining the bench, she was a prosecutor in the U.S. Attorney's Office for the Eastern District, and she was also a special master to Judge Weinstein in the Agent Orange litigation. Before turning the microphone over to Judge Cote, I just wanted to speak very, very briefly about my interactions with Judge Weinstein. Judge Weinstein was remarkable for his ability to connect with people in many different parts of the profession, including in the academy, and to bring a practical bit of wisdom to academic theory, and also to take academic theory and give it a healthy dose of practical advice. Some years ago, when I was still relatively new to law teaching, I wrote an article about the interaction between bankruptcy, class actions, and other forms of aggregate litigation. The article was a sort of nerve-wracking experience for me because it was going to be the capstone piece in my tenure file. So the process of writing it and publishing it were particularly nerve-wracking. Shortly after the piece appeared, and actually even before I got my reprints back from the publisher, I received a card in the mail with a very thoughtful set of comments from Jack Weinstein. So after I picked myself up off the floor, I thought to myself, I hope he liked it, because, as I said, it was an important piece for where I was in my career at the time. And he had comments, mostly positive, some critical, but they showed his ability to really unfold the piece. He had clearly read it, thought about it, and interacted with it in a way that I might have expected from my colleague on the faculty, but not from an extraordinary judge of his stature, who was also someone managing a busy docket well into his 80s and 90s. I shared this experience with a couple colleagues on the faculty, and many of them had very similar stories to tell. Judge Weinstein was someone who was a producer of scholarly opinions and a producer of material that we as academics could talk about. But he was also a consumer and a critic of what we thought about in the academy. And I'll close with a final memory. Some years ago, on the 50th anniversary of the New York Civil Practice Law and Rules being adopted, the Institute of Judicial Administration here at NYU held a session where Judge Weinstein was really the centerpiece, because he had served as the reporter to that New York State undertaking to redraft civil procedure rules in the state. And he was classic. He was funny, occasionally a little acerbic about the process, with what he thought the CPLR had gotten right and what still needed to be reformed. Still engaged, still thoughtful, still someone who was an evangelist for procedural reform and innovation. And with that, I will now turn it over to Judge Cote.
Who's on mute?
Oh, Judge Cote?
There we go.
Thank you. So I've been asked to speak about my time as one of Judge Weinstein's law clerks. Yes, I was a lucky one. I had the privilege of being a law clerk for Judge Weinstein, along with Keith Secular, back in 1975. Yes, that is 46 years ago. Judge Weinstein had been on the bench 8 years at that time, and the hallmarks of his life as a judge were all evident way back then. His engagement with the pursuit of justice, and in particular with social justice, his work ethic, his energy, his multitude of interests and engagements, his egalitarian streak, his focus on accomplishing as much as he could every single day on every project he undertook, and there were so many. Let me describe a typical day in chambers and his courtroom as I remember them. I don't remember that he ever told us when we had to arrive for work in the morning, but we certainly knew that it was before 9 o'clock, because however early we arrived, he had already been there, it seemed like, for hours. and our court day was filled. He presided over many trials that year, and many were criminal trials. There was a 2-month-long trial, a prosecution of cops for running illegal wiretaps. And at least one of those cops was connected to the theft of the French Connection heroin from the property clerk's office in the NYPD. Another was a trial of Joanne Chesimard, a famous Black nationalist, on bank robbery charges. During the year I was with him, he wore robes during his jury trials. And if memory serves, he wore them whenever he was in the courtroom. But nonetheless, I remember him saying that he wore his robes because his mother wanted him to. So even then, he was itching to get rid of them. Often we would be picking another jury as we sent one out to deliberate. And I remember hearing stories that he once had 3 juries going at the same time. As for his management of his civil calendar, that mainly consisted of rulings from the bench on motions to dismiss and summary judgment motions, and of course, then the civil jury trials. So how did he use his law clerks? Did he really need us at all? Well, we help manage the paper flow, but it's a really good question if he needed us. We were at his side whenever he was in court, but he really looked to us very little. I remember he once called me up to the bench during the middle of a jury trial and whispered, "I can think of 3 ways to get that piece of evidence in. How many can you think of?" Needless to say, it was not 3. The only thing I can really remember doing to help during jury trials was quote unquote drafting the charge. I had very clear instructions. I was to find any extraneous words or phrases and get rid of them. In other words, whittle down that charge to the bare minimum. As for motions, the judge liked to rule from the bench. So our task was to write as succinct a ruling as possible that could be read from the bench after oral argument. A clear statement of the issue, a citation to the relevant legal principle, and then a short ruling. That was it. We would gather the federal reporters or other books, put them on a rolling wooden book stand, and wheel the books into his room. We would leave the briefs and the draft opinion on top of the book stand before we left for the night. When we arrived the next day, he would have marked up the draft and added whatever he wanted to say. Then later that day, he would go out to the courtroom and rule from the bench. Voila, that was it. The motion was over. Of course, Judge Weinstein didn't always rule from the bench. He liked to publish at least 2 opinions each year on an issue of evidence. Of course, that was one of the many areas that he absolutely owned. And he also liked to file about 2 opinions of length each year on a challenging case that had implications for an industry or for an area of law. So we were able to work with him on those projects too. Again, he was in charge. I did my best to draft something he would find useful, but my draft was only the first of many drafts. I felt wonderful if a passage or a section that I had created survived. Judge Weinstein's energy seemed inexhaustible. He was an incredibly busy district judge, but that consumed only a portion of his working day. He was drafting speeches, revising one of his treatises, writing articles, and sending out notes to colleagues and friends. He did all this on the edges of his workday, and he did it every single day. Day in and day out, he was so busy and so productive that he seemed like a force of nature, as so many of us have said about him. In closing, let me say that as grateful as I am to have had his example as a judge, I am as grateful for his friendship in the years that followed. I got to experience his generosity, his kindness, his sensitivity, his sympathy, and I will always miss him. Thank you for this opportunity.
Thank you, Judge Cote. Before I turn the microphone over to Marc Falkoff, I just wanted to remind participants that for CLE purposes, I will read a code at some point during this hour, and then repeat it before the end of the session. Marc?
Thanks. Wow, does Judge Cote's description sound familiar? Well, thank you all very much for inviting me to participate. I thought I'd say a few words about how Judge Weinstein came onto my radar as a law student, and then a bit about one of Judge Weinstein's project that he let me work on with him, which was helping to resolve habeas backlog in the Eastern District. So the first time the judge really hit my consciousness was while I was working as a summer intern at the NAACP Legal Defense Fund. It was the summer of 1999 or 2000. And looking back, I now know that I had already been introduced to Judge Weinstein's work. His 50-page opinion, so one of his shorter opinions, that had been discussing the history of mens rea in United States v. Cordoba Hincapié, had been excerpted in the criminal law casebook I was assigned as a 1L, and it's the same casebook I now teach criminal law out of. Now, new law students tend not to pay attention to the authors of opinions, so honestly, the authorship of that pretty cool opinion, which was about the sentence for a woman who had smuggled heroin into the country thinking she was smuggling cocaine, didn't really stick at the time. But at LDF that summer, I was assigned a small research project as part of an effort to petition President Clinton for clemency on behalf of a young woman who had received a 24-year sentence for serving as a drug mule for her boyfriend, who was a drug kingpin and who was psychologically and physically abusive. And my task was to find support for the proposition that a defendant who suffered from battered woman syndrome was an appropriate candidate for a downward departure under the sentencing guidelines. And the idea wasn't to re-argue her sentence, but instead to show a variety of factors that could legitimately have led to a less draconian sentence. So as I remember it, my first run through the legal databases yielded just a handful of promising opinions, although there were several that went into some nice depth about the issue. And then I noticed that all the really interesting opinions came out of the same court, the Eastern District of New York, which was a little bit disappointing. And of course, I quickly saw that they had all been authored by the same judge, Jack Weinstein. And when I put all of that together, I turned to one of my co-interns and I said, with a very healthy dose of chutzpah, dude, this is the judge I'm going to clerk for. And I do believe we said dude in that era. For some reason, God didn't punish me, and I was actually given the opportunity to clerk for the judge a few years later. I'll also just mention that in preparing for my clerkship interview with the judge, I read through a trove of his opinions to try to really get an understanding of his judicial approach. And I distinctly remember spending an afternoon reading Martin Buber's I and Thou, because the judge had referenced it in an opinion. And I eventually conceded to myself that I had set myself a quixotic task and I was not about to solve Judge Weinstein with a few days of studying. So with that preface, let me just say a word or two about the judge's habeas project. As everyone knows, Judge Weinstein was a problem solver. As it happened that year in Chambers, the year that I was clerking with him, we didn't have any complex litigation. The judge had just wrapped up his guns litigation. He hadn't yet started on tobacco. Maybe he was feeling a bit antsy, but you knew he was looking for a new project. Of course, one thing that was clear to everyone in Chambers is the judge was always attuned to systemic inefficiencies and injustices and the matters that came through. During my clerkship here, the judge seemed to grow increasingly interested in the intricacies of the Anti-Terrorism and Effective Death Penalty Act, or AEDPA. And as you all know, with respect to habeas petitions from state prisoners, AEDPA lays out a pretty tough set of standards for granting the writ. There are time bars and restrictions on evidentiary hearings, and the standard for awarding the writ is, to say the least, highly deferential to the state courts. And we had a couple of tough writ denials in chambers that year. And I just had the sense that the judge really wanted to do a deep dive into EDPA. Maybe that's right, maybe that's wrong. But one day in the spring, Judge Weinstein came back from a judge's meeting and told me about a backlog in the district of more than 500 state prisoner habeas petitions, many of which had been pending for over a year, some of them much longer. The judge correctly, I believe, thought the backlog was due in large part to the effects of EDPA, which had gone into effect in spring of '97. The 1-year filing period had clearly led to an avalanche of petitions during the first year, and strange that it was in effect. And pretty strangely, the surge in filings had remained high during the following years. So the judge felt that many of the petitions that could have been easily and quickly resolved on the merits might have been getting mired down in chambers that were punctiliously drafting lengthy opinions, walking through all of the procedural reasons for denying the writ. And he told me that he was thinking of helping his colleagues out and offering to take all of the petitions, or as many as his colleagues were willing to give him, take them off their dockets and move them on to his. And he said that he thought with the help of a special master, he figured he'd have enough time to devote to the petitions and get rid of all of them in a year. He also thought he might have some suggestions for improving the efficiency of resolving petitions in the future. So he asked me if I'd be interested in helping with the project. And of course, I said I would. And that started off a pretty remarkable year for me. 500 of those Section 2254 petitions were transferred to the judge's chambers. First order of business was explaining in an order the legal and moral reasons for resolving these petitions expeditiously. We dove into the work of gathering complete records with the help of Eileen Levine and of course June Lowe. We walked through potential time bars. We figured out which petitioners had died during the pendency of their petitions, which ones were no longer prosecuting their petitions. So reading through all of the materials, all the arguments, all the record was a heavy undertaking, and the judge would start it early in the morning. He'd work it around the rest of his docket, and he was always ready for more the next day. So with that, I can reveal to you a little known fact. Judge Weinstein was a tireless worker well into his 80s and beyond. I know that's not really a surprise to anyone. The judge initially intended to hold a hearing for every one of those hundreds of petitioners, not least to signal to them that they were being heard and respected, even if their chances of succeeding on their petitions was very small. But the judge eventually realized that even for him, that particular goal was too ambitious. By the end of just under a year, he had disposed of every one of the 500 that had been reassigned to him. He granted the writ 10 times for a grant rate of 2%, which is not a huge number, but it's about 5 or 6 times the national grant rate at the time. He also drafted a final report on the project. He offered recommendations for more expeditiously deciding the cases. The final report included a primer on EDPA and 2254 petitions, which I think might have been helpful in a few chambers in the district for a while. And it was all done in under a year, pretty intense to be a part of. So wrapping up, I guess I don't know that I'm going to add much of anything to what everyone who knows the judge already knows, but some of the things that impressed me about working with the judge on the habeas project were just, as everyone will comment, his incredible stamina, his sincere desire to help out his colleagues, and really his just predisposition to looking for ways to improve the functioning of the courts in a way that paid appropriate respect to everybody. So Judge Weinstein, he accomplished so much over the years, but the habeas project just crystallized a lot of what made the judge special to me. So thanks.
Thank you very much, Marc. And I want to compliment you and Judge Cote for condensing a lot of wonderful thoughts and comments into the 7 or 8 minutes that we unreasonably gave you. Let me turn the microphone now to Ken Feinberg. Ken?
Thank you very much. Everybody knows about Judge Weinstein's lasting impact on the law, evidence, and civil procedure, and torts, and criminal law, criminal sentencing, products liability. In my experience, believe me, don't underestimate his lasting impact on case management. It was Judge Weinstein who appointed me special master in the 1984 Agent Orange product liability litigation, settlement master. And that began a 35-year tenure in the closing of the Shoreham nuclear plant, asbestos, DES. I was called on repeatedly by the judge to be his court-sponsored, court-appointed special master. And I think the current use of special masters and consultants appointed by courts, there's a direct line from what Judge Weinstein did in Agent Orange. There had always been discovery masters and that, but the use of a proactive court-appointed special master to help mediate and resolve disputes, I think he played a lasting role in that, and that's why it's so much more common today, I think. Now, Judge Weinstein's rules for appointing special masters, he had to have complete trust. He had to know the special master. He had to know well the person he was appointing. And although in a major complex case, he would get scores of letters and resumes, if you're going to appoint somebody, would you consider me, etc. He relied on personal relationship to the person that he wanted to help manage complex litigation. I knew Judge Weinstein because we had both clerked 27 years apart with Chief Judge Stanley Fold of the New York State Court of Appeals, a judge that Weinstein revered. He revered Judge Fold. And I got to know Judge Weinstein quite well as a member of the Fold Law Clerk Alumni Society. We meet annually. And Agent Orange, he contacted me and said, I want you. I said, I've never been a special master. I've never been a mediator. And he changed my career. I mean, that one appointment meant everything. And after that, he would call me and say, I need you for Shoreham, the closing of the nuclear plant. Governor Cuomo's on my back. I need you for asbestos. I need you for DES. And on and on. Now, if I wasn't available, he would call on somebody else who he knew and trusted, Judge Scheindlin. His former law clerks, Richard Davis, Peter Wooden, he called on people that he knew would do the job. Now, he had a very interesting approach to special masters. Today, when you hear about a special master being appointed somewhere, and everybody agrees the special master will not insinuate herself or himself with the judge, there will be no ex parte conversation. Judge Weinstein didn't believe any of that. He was the puppet master. He wanted to know from his special masters what's going on. Not the details, not the substantive terms, not the dollars. Ken, what's going on here? How can we accelerate settlement? How can we move this along? And he would constantly, on a daily basis, monitor my work and ask, without disclosing X company is being recalcitrant or why plaintiff is not being, he didn't want to hear about that. Just get it done. How can I help? So I think my role with him, I was joined at his hip for almost 40 years in these assignments that he gave me and his clerks and Judge Scheindlin and others. He also used very, very interesting, innovative case management instructions. During the days when I was the special master for the asbestos docket in his court and the DES drug docket in his court, he would coordinate with the state Supreme Court judges who had asbestos and DES cases. And he, on 2 occasions, went over to the state Supreme Court when Helen Friedman was sitting as a Supreme Court judge in the Supreme Court in Foley Square, and they conducted simultaneous state and federal hearings on pretrial motions governing asbestos and DES. In DES, when I was his special master, the leading lawyer, very good woman, plaintiff lawyer, Sybil Shainwald, came to Judge Weinstein and said, Judge, Ken Feinberg's the special master. He's suggesting that I take X dollars for 28 DES, individual DES women. And I don't think I can get them to settle for the dividing up the money for the 28. He said, Sybil, if it'll help in chambers, he said, bring in each of the 28 women. Let me talk with them in your presence with DES defendant counsel and the special master. All 28 accepted the money. After the judge explained the alternatives and held their hand and commiserated with them. So I believe that his case management techniques may last a lot longer than some of his doctrinal views of the law. And I think more and more today you see judges adopting his case management orders and his special master orders and his coordination with the state judiciary, which he felt strongly was important. He did all of that. Two final anecdotes, and I'm done. In the 1990s, or whenever it was, it might have been after 2000, Judge Weinstein decided to take senior status. But he was very concerned that he'd be taking senior status and opening up a vacancy on the Eastern District. Now, you may recall that he was nominated by Lyndon Johnson at the urging of Bobby Kennedy. Probably the only time Kennedy and Johnson ever agreed on anything. And Bobby Kennedy was no longer alive. Judge Weinstein got on a train, went down to Washington and asked for a private meeting with Senator Ted Kennedy. And Kennedy asked me, he said, why is the judge coming? I said, I'm not sure. Kennedy said, of course. And Judge Weinstein came in and said to Senator Kennedy, look, I think I'm taking senior status, but your brother was the one that asked me to serve, and I really don't want to do this, Senator Kennedy, if you think it's a mistake. It's a lifelong appointment. And if you want me to stay as an active district judge, I will do so. Of course, Senator Kennedy said, my God, you're coming down here to ask me because my brother's not alive? And the answer is, of course, Judge, you can. And occasionally he went to Senator Kennedy's house when we had dinners and talking about changes in the law, etc. And the final story is one that some of you may know. When Stephen Breyer was chief judge of the First Circuit Court of Appeals, Judge Weinstein got a call one day from Breyer. Jack, we've got a real dilemma in Puerto Rico, part of the First Circuit. And I've got to reassign a judge. And frankly, the judges down there, they know each other. There's a perception. If I give it to another judge, would you be willing, Jack, at my urging, to go down to Puerto Rico and try the case and handle it as a visiting judge appointed by the First Circuit? And the judge went down to Puerto Rico for about a month. Another example of how the federal judiciary, Breyer picked up the phone and called Weinstein and asked him to get down there and take on that assignment. And he did it with a little fanfare, very quiet, and got the job done. So case management and these anecdotes are what I'll always remember about the judge and what he meant to me. And of course, my career is directly attributable. I love judicial patronage, and I love Judge Weinstein.
Thank you very much, Ken. Before I turn to Judge Gleeson, let me read the CLE code. The CLE code is CCJW2. Again, that's CCJW2. And I will repeat that before the end of our session. Now, I believe, Judge Gleeson, you were appointed to fill the vacancy created by Judge Weinstein's going senior. So it's appropriate that you follow Ken Feinberg's remarks.
Yes, thank you, Troy. And thanks to the law school and to the Center on Civil Justice for paying homage to the great Jack B. I can't tell you how flattered I am to be part of this and to be part of this elite group of speakers. And, in trying to figure out how I can contribute, my distinction here is limited to growing up as a trial lawyer in Jack's courtroom. And then just when he thought he was making some progress with me as a trial lawyer, then I got appointed to the bench and he had to teach me how to be a judge. And so I spent 32 years, 10 in his courtroom, 22 every morning having coffee with him. And you've begun to hear already the things that make him arguably the most significant judge on any court in our lifetime. But what I'll share with you in my few minutes is a few things about the great Weinstein that you have to try cases before him to know and have to be his colleague to learn. Before I was a judge, I was a prosecutor, and I tried several cases in his courtroom. I was in his courtroom a lot. And it was always an unbelievably pleasant experience. By the time I came along, he had jettisoned the robe. He didn't wear a robe at all. He would, and unless he was on trial, he didn't even sit up on the bench. Rather, everybody sat around these conference tables, one in particular in the well of the courtroom, where conversations were had and family members of defendants were invited to come join him. And it was very civilized, much more like a book club meeting than a courtroom appearance. And the rules of engagement were different, which took getting used to. I learned the first time I learned it what in retrospect is an amusing way, but it seemed like a hard way at the time. I was in the courtroom on a drug trafficking case for the first appearance. And in every other courtroom, those appearances were pro forma. Another date was set, a schedule was set. But this was Jack's courtroom. And he asked the defense lawyer in the first appearance if he anticipated filing any motions. And the lawyer said he was thinking about maybe moving to suppress some statements and moving to suppress the fruits of what the government claimed was a consent search. And we were sitting around the table in the well of the courtroom, and the judge turned to me and pointed with his chin to the man sitting next to me, who was the DEA agent. He said, "Is this your agent?" I said, "Yes." The judge said, "Raise your right hand," and swore him in, turned to me and said, "Go ahead." And my poor agent, who had been sitting there in this kind of Starbucks atmosphere, all of a sudden was wide-eyed, turned to me and said, "What's happening?" I said, "I think we're in the middle of a suppression hearing." So I had to start asking my questions. Trials themselves were a joy in his courtroom. He knew a little bit about evidence. And Dee mentioned this earlier. I had a trial called U.S. versus Florence Obaya Bona. It was a typical buy-bust drug case. And I offered into evidence a bit of a tape recording that occurred several minutes after the transaction occurred. And the agents had closed in and arrested the undercover agent to make things look good. And the undercover agent made a critical statement post-transaction, still on the recorded conversation. I wanted that into evidence. I offered it into evidence. And at the sidebar, Jack made a very eloquent oral opinion about why the present sense impression exception to the hearsay rule applied. And further to Dee's point about how he would think of different ways that items might get into evidence, I'm headed back to the podium, content with my ruling, and he called us back to sidebar, and he said, "Just in case those people up there in the Second Circuit don't understand that ruling, let me make another," and proceeded to make an equally eloquent oral ruling that the statement was also an excited utterance. And I remember thinking, as I was again returning to the podium, that guy sure knows how to make a good record, and given his propensity to bait the Court of Appeals, it's a good thing he does. He was, of course, an author of the Bible on the rules of evidence and knew them inside out. But I'm here to tell you that there were rules of evidence in Jack's courtroom that you can't find in Weinstein's evidence. One of them, which I ran into a couple of times on trial, is the "you've got enough" rule of evidence preclusion. And each time it was the same. I would pose a question to one of my witnesses on direct examination in the government's case, and I would hear "sustained" come from the bench. And I'd scurry up to the sidebar and I would say, "Judge, this is a perfectly admissible it was a perfectly fine question. The evidence is admissible. I don't know why you said sustained, especially since nobody said I object." And he would say to me, "You've got enough evidence already. Let's finish up the trial." Being the nerd lawyer I was, I thought he was saying I was eliciting cumulative evidence. And I would make that argument. He'd cut me off and say, I'm not saying it's cumulative. I'm saying you have enough evidence already. So let's get the trial over with. And he'd have that first time he did it, had that big smile on his face. So I knew it was okay to push back. And I said to him, "Well, Judge, I'm glad to hear you think we have enough, but you don't get a vote. Like, there's 12 people over there and they're the ones who vote." I said, I'll make you a deal. Raise your hand. Tell the jurors, if you've heard enough, raise your hand. And if all 12 of them raise their hand, I'll rest my case. And he says, "No, let's just excuse this witness and you'll proceed to your summations." And then, knowing he had the last word on this and being the mischievous person that he was, he pointed to the court reporter and say, you have your record for appeal. To which all I could say was, as soon as they amend the Constitution to remove the prohibition against double jeopardy, that appeal is going to serve me fine. But he was, just a delightful person to appear before. Then I became his colleague. And boy, did I need him as a colleague. He was the single most generous person I knew in life generally, and was that way as a colleague. Anytime, I remember so vividly him coming into my chambers back in the mid-90s when I was a brand new judge, and I was trying to figure out whether I could grant a motion to join or separate, I've forgotten which. And he happened to walk into my chambers, as he did frequently, to ask how I was doing. And I was thinking, should I ask him? Here's a man who knows how to put 10,000 complainants into one lawsuit. You heard about this from Ken. Should I actually ask him about the rules of severance and joinder? But I did, and he would sit down and answer the question and answer my questions. He would come to chambers every September, even to the chambers of the Irish kid, to every judge on the courthouse, and wish them a happy new year. My clerks would all come out to get to be in the presence of the great Weinstein for just a few minutes. And then he would leave because he had to visit all the other judges in the courthouse. He would write notes to us on these little note cards, the old-fashioned way. In my office now at Debevoise, I have framed 6 or 7 of the notes that he wrote to me that were dear to me. And they are among the 90 notes. I didn't keep them all, but I counted them. 90 notes that he wrote to me. And he didn't just write to me, he wrote to all of his colleagues, consoling when you had a personal issue, excuse my dogs, complimenting on an opinion. He was such a giving and wonderful person. And I'll finish by saying this. Jack Weinstein taught a generation of judges, including me, how a district judgeship could be a platform in which to administer justice, in the first instance, to administer justice to people whose cases made it onto no one else's radar screens, but the Article 3 judge before whom they appeared. But those cases were fundamentally important, sometimes life and death to them. And he taught us the importance of paying the commensurate attention to their cases. And he taught us the importance of using that position as a platform to inform policy. Because, to take one issue near and dear to my heart, the people best in a position to comment upon, to write about the consequences in human terms on three-dimensional people and their families and communities of sentencing policy are judges. Not all of my colleagues felt it appropriate to speak out and to try to influence policy. Jack thought it was not only appropriate, but essential and integral to doing the job the way it was meant to be done. I will go to my grave. I found myself, as much as I love Jack, not feeling mournful when he passed. We should all live as long. We should all accomplish half as much. But his life is worth celebrating for so many reasons, including what he inculcated in terms of a sense of purpose in a generation of judges. So thank you for allowing me to be part of this. I look forward to hearing my other colleagues' comments about the great Jack B. Weinstein.
Thank you, Judge Gleeson. Let me turn to my colleague, Burt Neuborne. Burt?
Thank you, Troy, and thank you for letting me participate in this and have a formal way that I can express the sadness, but also the way John Gleeson just said, the joy I feel in thinking about Jack's life. It was a remarkable life, and in the law and out of it. And it's wonderful of you to put this together, to think about it. I want to take us back to the days when Jack was a young, recently appointed judge, 1969, when he was sitting on the Eastern District at a time of the court's greatness. There was a time when the Eastern District was, I think, the finest collection of trial judges ever put together. I mean, with Jack Mishler as the chief, and Orrin Judd and John Dooling and Gene Nickerson and Jack Weinstein sitting as trial judges. I'm not sure that collection of talent has ever been replicated on a trial bench anywhere. But Jack was the first judge before whom I tried a federal case. I tried my first federal case before Jack in 1969, and it was a school desegregation case coming up out of New York City, where local school boards were doing everything they could to segregate and resegregate efforts by the central board to desegregate the schools. And they stumbled on a terrific idea for racists, and they used the truancy rules. So if a school had been integrated, they would just wait until Black kids missed a couple of days, and then they would declare them truants and throw them out. I was newly at the New York Civil Liberties Union as a trial lawyer. Had never tried a federal case, and interviewed a group of parents who told me about this. And so I put together a complaint, filed it in the Eastern District. It was assigned to Jack, and then set about trying to negotiate a resolution with the city board, because the city board expressed anger at what the local board was doing. So I negotiated for about 2 weeks, didn't get very far. And on a Thursday night, I got a telephone call. And I pick up the phone, and the voice says, is Burt Neuborne there? And I said, yes, this is Burt Neuborne. And he said, well, this is Jack Weinstein, the judge that before whom your case is filed. I said, yes, sir. I thought he was going to call and ask for some sort of status report or something like that. I said, yes, sir. What can I do for you? He said, well, first I want to know where you went to law school. And I said, well, I graduated from Harvard. And he said, well, didn't they teach you anything up there? Don't you understand that you're the lifeline for your clients? What are you doing letting these kids stay out of school for 2 weeks? I said, well, I was negotiating. He said, when can you be ready for a real trial? You are a real lawyer, aren't you? I said, yes. He said, when can you be ready for a real trial? I said, well, would tomorrow morning at 9 o'clock be all right? And he said, all right, just take the weekend and come in on Monday and we'll try the case. So somewhat shaken, I went in on Monday and started trying the case. And it was like trying a case before radar on MASH. The testimony would start coming in. I would start to stand to either object or say something. He would look at me, tell me what I was about to say, and then rule on it. So that I don't think I said more than 10 words in the trial, except to elicit testimony from my witnesses. Every time I try to say anything, Jack anticipated it and ruled on it. At the end of the trial, I expected a grade. I didn't expect a verdict. So he issues a verdict from the bench on Friday after 5 days of trial, reinstating the students and granting every possible relief I could think of. And I go home and I feel comfortable. And then several days later, I have to go back into his chambers. And I said, "You were right. I waited too long. They missed too much school. They need tutoring, or else they're going to be held back, and that would be unfair." So he said, "Sure, give me an order." So he signs an order requiring tutoring. 3 days later, I go back and say, "Judge Weinstein, I have something else." He said, "Well, what do you want now?" I said, "Well, the problem is there isn't enough time left in the school year. Could you order the tutoring to go on into the summer?" So he smiles and issues an order saying, "Yes, the tutoring can go in for the summer." So then I come back 3 or 4 days later and I say, "Judge, several of these young people have summer jobs and they need the money. Can you order the city to pay them for attending the tutoring sessions?" So he smiles and he says, "You're learning," and signs the order. 4 days later, I go back and I can't remember what else I wanted. And he said to me, "Are you here again?" I said, "Yes, sir." He said, "Wait a minute, I know just what you want." And he turns around, goes back into chambers, comes out 2 minutes later, gives me a piece of paper. And I look at the piece of paper and I wish I had it today. I don't have it anymore. I look at the piece of paper and it says, "Social injustice is hereby abolished in the United States. Signed, Jack B. Weinstein." And he said, "Here, take this. It's your diploma from Weinstein University. Don't come back." And we then, of course, over the years became what I hope were close friends and close colleagues. And I've received my quota, Troy, of cards from the judge. Every time I wrote something, there'd be a thoughtful card before I got my reprints. He read them so quickly, and those cards are some of my cherished possessions. I thought of him as a kind of primal force for justice, sitting in that courtroom, sending out waves. I mean, he transcended the physical world. I mean, he was really a manifestation of justice, sitting in that room, doing things that people dreamed of. And if there's a judge in a lifetime, a trial judge especially, who's done what he's done, I can't think of him. He has been a remarkable force. And I speak to him every day. I speak to him every day because I teach evidence. And Weinstein on Evidence continues to be the single most important resource for evidence teachers in the country. And even as he's gone, as I continue to teach evidence, Jack's voice is in my ear saying, "Oh, you misread that case. You got to get that case right. You're not quite getting that case." He was a giant, and I remember him with joy, and I hope all of us do. People like Jack don't pass this way very often, and it was a great, great honor to have been able to work with him. Thank you.
Thank you very much, Burt. And now let me turn to Judge Scheindlin to close out in the minutes we have remaining. Judge?
Thank you. Well, like every speaker before me, I'm so grateful for being given the opportunity to remember and reflect on my 45 years of knowing Jack B. Weinstein. Everyone has already said.
Shira.
Judge Scheindlin, your audio went off. I think you're muted.
Shira, your mute's on. The mute button.
Let's.
David, could you unmute?
Yeah, David, can you
Here?
try unmuting from?
Here we go.
No, she's still muted. David, can you try to unmute?
Shira.
Unmute. I can click the ask to unmute button.
How's that? Is it
There we
unmuted
go.
now?
There we
Okay.
go.
Okay.
Should I start again? Should I start again?
Better,
Yes.
yes.
Yeah.
Okay, I started to say, like every speaker before me, I'm so grateful to be given the opportunity to think back on my 45 years of knowing Jack B. Weinstein. Everything that needs to be said has already been said eloquently by all of the other speakers, but it all bears repetition because it cannot be said often enough when we're speaking of someone so wonderful. So here are my very personal reminiscences. My first encounter with Judge Weinstein was as a young assistant U.S. attorney trying my very first criminal case before him. The defendant took the stand. I stood to cross-examine and Judge Weinstein bellowed, "Sit down." I said, "But I'm about to cross-examine the defendant." He again said, "Sit down." Respectfully, I asked for a sidebar. He motioned me over. I started to speak, but he quickly interrupted and said, "Sit down. Anything you ask will only hurt your case. Things are going perfectly for you." And he grinned from ear to ear. I meekly returned to my seat and the defendant was swiftly convicted. When Judge Weinstein was chief judge, I had just been appointed a magistrate judge in the Eastern District. The Agent Orange case had been supervised in the Long Island courthouse by Judge George Pratt. When he was elevated, although not all of us thought it was elevated, but when he was elevated to the Second Circuit, the case was reassigned to Judge Weinstein. Saul Schreiber had been the special master supervising discovery with Judge Pratt, but when the case came to Brooklyn, Judge Weinstein decided that one of the magistrate judges should be the special master. Well, the senior one, Cy Crine, had a conflict, and the next senior, John Caden, had been a soldier in Vietnam, so the task fell to the brand new magistrate judge. Thus began 2 years of very close collaboration with Judge Weinstein, who delegated all of the discovery work to me while he dealt with the dispositive motions and settlement efforts. I can only tell you he backed me all the way. I will never forget the morning the trial was scheduled to begin. He told me to go out into the courtroom, select a jury in this closely watched high-profile case. In the meantime, he was locked in his chambers, very secretly meeting with Ken Feinberg and teams of lawyers, settling the case because everyone knew that the trial would begin in an hour. That's because the jury was being selected. High drama would be an understatement. After the settlement was announced, he turned to me and said, "Now you need to figure out what to pay all those plaintiffs' attorneys." And I did, and I was affirmed, and he was affirmed, and that was Jack. When I became a district judge, I had no better cheerleader, supporter, and advisor than Jack. His handwritten notes of praise, which everybody has talked about, are legendary, but you have no idea. Every time an opinion of mine was noted in the law journal or the press, I received a note of praise from Jack. Ditto for any speech I gave or article I wrote. I recall one time we were both speaking on the same program. I confided to him that I was very troubled by the mandatory minimum sentences I was required to impose and was thinking of resigning rather than sentencing someone to what I deeply believed was an unfair and inappropriate sentence. Jack talked me out of it. He sternly said, "Well, how will that help? Someone else will just take your place and have to impose the same sentence, or worse yet, a longer sentence than you would have had. You can do far more good staying where you are and fighting for greater justice in sentencing." Of course, I took his advice and stayed for many more years. I always took Jack's advice. When I issued my decision in the Floyd case, which ended New York's inappropriate use of stop and frisk, which violated the rights of thousands of Black and brown New Yorkers, I was fiercely attacked in the press. I was followed from my home where reporters with cameras were camped out. I'd always walked to work from Brooklyn to Manhattan, and this time the press followed me, rudely shouting questions. On the first day after the decision was released, I was walking to work and I ducked into the Eastern District Courthouse quite shaken. I went straight to Judge Weinstein's chambers. He was so dear. He gave me the warmest hug, told me how wonderful I was, and that he loved me, and that my decision was right. He then called the U.S. Marshals, walked me into the lobby himself, and ordered them to drive me over the bridge. That was Jack, the dearest of men. I have many other memories. We had many lunches in restaurants. We met for lunch in his chambers right until the time he left chambers. I remember his fabulous 95th birthday party. And I recall his accepting my invitation to present me with the Stanley Fuld Award, the judge that he and Ken Feinberg clerked for from the New York State Bar Association. He wrote the most wonderful introduction. I also remember the day I told him I decided to retire from the bench. After his initial reaction of disappointment, he suddenly said, "I totally understand why you made this decision. I know you want to do good things, so go out there and do good things." That was Jack, the dearest man, the dearest friend anyone could have. His passing is a great loss for me and for everyone here, and for the legal profession, and for the world. Thank you again for this opportunity.
Thank you, Judge Scheindlin. Before closing, let me repeat the code for CLE. Again, it is CCJW2, CCJW2. And now I think we will go directly to the second panel, and I turn things over to my colleague, Sam Issacharoff.
Thank you, Troy, and thank you for the wonderful first panel. We have another great panel here. I will take the moderator's privilege of telling two anecdotes before introducing the panel. And the first one picks up on what Burt Neuborne was talking about, his role in desegregation cases in New York. My first exposure to Jack Weinstein occurred the day before my first day of law school. In typical fashion of some law schools, I was assigned a Weinstein opinion to read for the first day of class. And the opinion was Hart v. Coney Island School Board. And it was a mere 240 pages of single-spaced monograph. And I sat down to try to read this because I am able to go John Gleeson nerd for nerd with the best of them. And I read and I read and I read. I confess I didn't know much of what was going on, but I got to the point where a special master, Kurt Berger, a Columbia law professor, was redoing the zone fares on the New York City subway and rerunning the bus routes for the MTA. And I read this and I thought to myself, where in the Constitution does this man, Kurt Berger, appear? And how does he take over the running of New York City? And I don't come from a legal background. This was one of the first cases I'd ever read. I'm not sure I still know the answer to that question, but it was quite an introduction to the scope of law in the hands of somebody like Jack Weinstein. Fast forward a number of years, I'm appointed the reporter for the American Law Institute's aggregate litigation endeavor. And one of my advisors is Jack. And before the first day of the first meeting of the advisors, Jack and I go for breakfast together. And we're sitting there and he says to me, you know, it turns out I talk too much and I don't listen enough. So I'm just going to sit here today and not say anything. And you run the show the way you think is best. And I'm just going to listen. I thought, wow, mid-80s, he's finally mellowing. I'll believe it when I see it, but we get into the room and there's a number of very distinguished people, a number of great judges, all sorts of folks in there. Jack sits front and center, first row, and I start to talk and maybe got 1-2 minutes in, hand goes up immediately, right in my face. It's Jack. So I say, Jack, or Judge Weinstein, what can I do for you? And he said, I think your entire approach here is misdirected. I think what you should really be looking at is how we try individual cases with aggregate proof, because the law doesn't well handle the relationship between aggregation and individual claims. And this is a mess, and this is what you have to deal with. And it's true that that's a critical issue to this day. And it is true that it is something that we tried to get to in the project and couldn't quite handle. But the ALI is heavily a backward-looking methodology of trying to make sense of what has gone on in the courts. And what that episode showed me was that Jack was never going to be backward-looking. He was temperamentally incapable of using that as the template. He always wanted to push forward. And so he wouldn't even give me a full 5 minutes to try to bring the world up to where he was or close to it. It had to be the next step forward. And he was a wonderful man. There's so many stories. I also got those postcards. For a few years, I indulged the fantasy that I was the only one, but we now know that it was just remarkable, his impact on people. So let me introduce our panel in the order in which they'll speak. We have Sheila Birnbaum, and this is a panel that really needs no introduction, but Sheila's a partner at Dechert. She is one of the great mass tort lawyers. She used to be a professor at NYU and then created the field of mass torts in private practice. Following her is Elizabeth Cabraser, and everything that Sheila does on the defense side, Elizabeth does on the plaintiff side. She's the lead partner now in Leiff Cabraser and is just the dynamo of the plaintiff's bar in mass torts. Chris Seeger is from Seeger Weiss. Chris is going to talk about his relations with Jack and how he started off in the mass tort world, really learning from and working for, in fact, Jack Weinstein. And then we have 2 law professors, both of whom were clerks to Judge Weinstein. First, John Goldberg, who's the deputy dean and Carter professor of general jurisprudence at Harvard Law School. Only Harvard distinguishes general from specific jurisprudence, but that's fine. John clerked for Jack and then for Byron White on the Supreme Court. And finally, we'll have Adam Zimmerman from Loyola Marymount. Adam also started as a clerk to Jack Weinstein and then served as counsel to Ken Feinberg on the September 11th Victim Compensation Fund. So thank you all for coming. Sheila, it's all yours. Sheila, you have to unmute.
Thank you. It's the most famous words in the world since COVID is you're on mute. It's a great privilege to be part of this program with so many old friends who we haven't seen in so long. Jack became a friend of mine, which was very unusual, considering I always thought I was on the other side of the V from Jack, because Jack was an innovator, and he didn't believe that you just follow what the old law was, that the law was dynamic, especially in the area of torts, and especially in the area of mass torts. And he was creative. He just didn't sit and wait for things to happen. He made things happen. And he looked at things through the eyes of a equitable approach to this whole concept of mass torts before anyone recognized it as a concept. Agent Orange was probably the beginning, but it was certainly a landmark case. And as a student of tort law and as a professor of tort law for some time, I explored that case and at first didn't quite understand what he was accomplishing. He didn't give the plaintiffs a lot of money, but he gave them something because he thought that it was important. And if anyone opted out, they were dead in the water. If you were part of the group, you got part of the money, but it was a community that he saw that needed to get some compensation, not only from a compensation point of view, but from a larger point of view, to satisfy the societal needs to do that. And I think that was always his approach. Let me just say, from a personal point of view, the thing I'll remember most about Jack is the twinkle he had in his eye. He always had a twinkle and an enthusiasm that no one else had or could put together, and always cared about the people in front of him, whether they were the lawyers or the participants or the defendants, because he was a human being. He was a mensch. You know, that word fits some people rarely. It definitely fit him. He always looked beyond the immediate. He always looked beyond the law as it was written and tried to come up with creative ways to handle new situations, which clearly our mass torts were. I'd like to talk a little about one incident and the impact that it has today that he doesn't even know about. In the cigarette cases, and I'm sure that others will make reference to this, especially the cigarette cases and punitive damages. Jack had a concept that punitive damages just didn't work and may have been stopping settlements of compensatory damage. Didn't work when you had to sue over and over again. It was in some ways unfair to the defendants to be sued over and over again for the same course of conduct. There had to be an end to it somewhere. And why don't we do something really good with this money instead of somehow prorating it among a bunch of plaintiffs who may not get a settlement, may lose their cases, etc. And I had a client that was a cigarette company that was willing to talk about a concept of getting punitive damages as a class action, settling that class, and using that money for beneficial societal community issues, such as scientific research for lung cancer and treatment of people who had lung cancer or treatment for addiction to cigarettes. And he put us together with a group of plaintiffs' lawyers, health care professionals, and others. And we engaged in a mammoth round of mediations in which he was involved. And we came pretty close to creating a huge amount of money, especially in those days. We're talking about 25 years ago, in which there would have been lung cancer research on a scale that we have not seen or could have seen in a very short period of time. And unfortunately, it didn't work. And as a result of that came the Simon cases that I'm sure Elizabeth will talk about, and Elizabeth's article on how to do a mandatory punitive damage class. Well, remember, he tried so hard to get the parties to agree, and they actually agreed on monetary basis, but couldn't agree on some of the other issues around the monetary basis, which was really unfortunate. And he was heartbroken by it, and so was I as a result, and the client who really wanted to get the punitive damage element out of the cases and was willing to pay a lot of money to do that. Two things that I'm reminded of. I told him at some point when this began that I had tickets to Patagonia, and it was a really far way to go, and I hadn't had a vacation for a long time. And he said, "Don't worry, Sheila, we'll get this done. We'll get you out to Patagonia." And it continued and it continued and it continued. And I finally went to him, I said, Judge, tomorrow I have to get this done because I have to go to Patagonia. He said, oh, cancel it, put it off a day. You'll go the next day. Well, this happened for 4 days. And every time I canceled it, we made another reservation on the airline. And finally, of course, I said, Judge, I mean, I'm not going to Patagonia, and it's unfortunate that we haven't gotten this done. You cannot imagine how every time he saw me after that, he asked me, have you ever gotten to Patagonia? That was the kind of judge or human being he was. He was concerned that I had canceled that trip because of this and that it hadn't worked out. So in favor of Jack, we have now settled the opioid litigations under the same charitable kind of situation that he would have liked to see. The money that is in the opioid settlements are going to go to abatement. They're not going to states, cities, and counties to be used for roads. They're going to try to change the situation for those that were affected by opioids. I think Jack would have been proud of it. Jack should take credit for it because those go back to some of the concepts and thought processes he's had about how tort law could handle the societal issues in a very different way. So I give credit to Jack for what we're doing today because of his creativity, insight, and feelings of how to handle systems and processes different than anybody else. So I'll stop there, Sam. Thank you for the opportunity.
Thank you, Sheila. Before I turn it over to Elizabeth, for those who need the CLE credit, the code for this portion of the program is CCJW3. CCJW3. Elizabeth.
Thank you. And thank you so much for including me in this program for an opportunity to add my tribute to the many tributes to Judge Weinstein. Oddly enough, I agree with Sheila Birnbaum on many, many things. It often bothers me that is so, since we're on TV. But first and foremost, I know that Sheila and every lawyer on this program would agree with me that no lawyer who has ever appeared before Judge Weinstein has failed to have been utterly transformed as a lawyer by the experience in terms of what we strive to do for the rest of our professional careers, to live up to the vision that Judge Weinstein had of the possibilities of the law. Judge Weinstein lived within the four corners of the law. He had the greatest respect for it. He was a master of the law. He was a master of procedure and of evidence. And he never strayed beyond the boundaries of the law, but he understood that those boundaries were far, far wider than the bonds of convention. And he knew that the capacity and potential of the law to do justice was far greater than the accomplishments to date. So as Sam Issacharoff said, he was not interested in repeating a procedure, in doing anything that we all knew would work. Lawyers are risk averse. Judge Weinstein was the opposite. He was fearless. That courtroom was a place of fearlessness, of respect for the law, of respect and affection for lawyers, but a very demanding place. To give you one illustration, I will follow Sheila's description of one facet of the constellation of tobacco-related litigation that was before Judge Weinstein's court with another part of the case. It's the Simon II litigation. After that attempt to utilize Supreme Court precedent, part of which Sheila had developed, to cabin punitive damages via settlement. Judge Weinstein decided that we could do it in a trial, a three-phase trial, where the jury would first use statistical evidence, another one of Judge Weinstein's favorite things, as yet underutilized in mass torts, to estimate the totality of compensatory damages of a certified litigation class of people with tobacco-related diseases. The class wouldn't get the money, but that calculation would then be utilized by the jury if it found in stage 2 that a defendant's conduct warranted punitive damages, to then calculate the ratio between the compensatory damages of the class and the punitive damages that should be awarded to fulfill the societal interest in deterrence. But again, the class wasn't going to get that money. Judge Weinstein was going to work with special masters, with class counsel, to find the best uses of that money, again, to vindicate the societal purpose of punitive damages. And in doing so, would solve what he saw as 3 very simple problems. There was a procedural problem. It cost too much to take a tobacco case to trial, and even the plaintiffs who won were losing. Number 2, there was an evidentiary problem, and you've heard about it on this program, which is that in aggregate litigation, in any sort of mass tort, individualized evidence doesn't match up well, in Judge Weinstein's view, to the harm, the totality of the harm, and the way that compensation should follow the harm. And of course, there was the equitable problem and the societal problem, which was that even if you could find an efficient, cost-effective mechanism to get everybody to trial and get them their damages, the purpose of punitive damages would still go largely unfulfilled. So he elegantly solved the problem with the trial. That was as far as the lawyers on the plaintiff's side were willing to go. We couldn't see, our vision didn't reach, our imagination failed beyond that point. And I remember Judge Weinstein's disappointment because we couldn't figure out how also to address the futures class issue and have a truly comprehensive resolution of all tobacco litigation for all time, right? Could have done it through a settlement. That didn't work. He wanted to do it through a trial. We couldn't figure out how to get there. We gave him half the solution, which in a 108-page decision in the Simon II litigation, certifying the class, structuring this multi-phase trial, and inviting the Second Circuit to a dialogue with him on this, he characterized this approach as conservative. This was probably the first time I had been described as conservative in one of my cases. I was a little annoyed by it, but it was an object lesson, which was that as an advocate, as someone trying not to go too far, trying not to risk too much, I was not going to be able to exhibit or implement the true fearlessness of a federal judge who understood very well the boundaries of his power and authority, and who also understood, as I believe too few judges do, that the courtroom in which he sat was a court not only of law, but of equity. When law and equity merged in the federal system, somehow equity all but disappeared, but not in Judge Weinstein's court. It always lived, it was always practical, and it was always his goal, I think, in every case that came before him, large or small, involving many or few, involving civil or criminal claims, to utilize his powers under the law to do equity to those who appeared before him. I've never forgotten the experience. I've never forgotten that the law still has those possibilities. And even today, we are still, as Sheila said, taking some conservative bits and pieces of the grand vision of Jack Weinstein and applying them and utilizing them to advance the law of aggregate litigation. And for that, all I could say is, Judge Weinstein, thank you now and thank you forever. Thanks.
Sam, can you hear me okay?
Yes, Chris, go ahead.
I have so much I want to say about Judge Weinstein. I don't know where to start. And I started making notes, and this is what they look like. It's just scribbled. So I'm going to do my best to do this. So I thought of him as a rock star. You might have to turn your volume down there, Elizabeth. Elizabeth and I are in the same room. I thought of him as a rock star before I even went to law school. When I started out as a carpenter. I went to Hunter College. I was in a pre-law society. And a lawyer would come in from time to time to talk to us, and he always talked about this great judge, Jack Weinstein. I've been practicing law for 31 years, so we're going back 37 years, maybe 36 years. So I knew about him, and when I decided I wanted to go to law school and I had some options, I called this particular lawyer and I said, what do you think about these schools? And he said, go to Cardozo. Jack Weinstein really likes Cardozo Law School. He hires clerks in there. So to make a really long story short, he was this mythical figure before I started practicing law. And then I got lucky to wind up in a case before him, which was really one of the first in many ways. I mean, it was the Zyprexa litigation. It was probably one of the first, if not the first, large global non-class aggregate settlement where a judge really kind of took control. And this is going to lead to my story and about his influence on the law. It involved an antipsychotic drug called Zyprexa. The people who took it, the judge was very concerned about from day one about their capacity, not only to understand the litigation, but to contract with their lawyers. And he was concerned about the terms of the settlement, and he was very, very hands-on. And I have to say one other thing about things that have been mentioned here, and it was part of something I wanted to talk about. His style of active case management, I had never seen anything like it until I was before him. Now, since then, I have been before other judges in other large cases and MDLs who followed suit and they'll direct you right back to Jack Weinstein on how he ran cases. We would sit in chambers, and those discussions were creative. It wasn't what's your problem today and what motion can I rule on and how can we resolve it? It was, how are your clients? What are the problems you see? If you did this settlement, how would you structure it? What do you guys normally do? He was very familiar back then with class actions, less so with mass torts. And when we finally had reached an agreement in the case, we had a pot of $700 million. I went to him with a couple lawyers and I said, some of my plaintiffs' friends might be angry at me for admitting this now, Elizabeth won't be, but I said, Judge, the practice today is kind of you send the money to the law firm and they distribute it to their clients. And he didn't like that at all. And he said, it was clear, and in these discussions, he was going to grab control of two things. One is the fund and the attorney's fees. The fund he solved the way he typically worked. He called in Ken Feinberg and he called in a special master. And we basically handed the fund over to the special masters. And I just broke Joe Rice's chair. And they did the allocations and they decided how to whack it up. On the attorney's fees, some folks may be familiar. I know the professor, Sheila, Elizabeth is, but he wrote an opinion where he coined the very first quasi-class action. And to this day, I'm not really sure why he felt he needed to go there, because I think he could have controlled fees as judges cite today under the MDL statute, under his powers to regulate attorney's fees. But he wrote an opinion where he called this thing a quasi-class action. And the way he anchored it is he said, there are 8,000 claimants. There's a large fund that the court has control of because we created a qualified settlement fund, and he had to sign an order to do that. It involved special masters, and he had a whole list of things, none of which really justified calling this thing a quasi-class action, but got him exactly to where he wanted to go. And that was, he was very comfortable with Rule 23. He liked the way attorney's fees were handled there. And he wanted to do that in this case to protect the clients, to make sure that they got the benefits, the clients got the benefits of the efficiencies of an MDL, not just the parties litigating. And because of those efficiencies, he wanted to reduce the fees, and he did in fact reduce the contract fees, and he wanted to control the amount that was awarded and the allocations that were done. My memory doesn't serve me all that well, but I think Ken Feinberg might have been involved, or another special master might have been involved with how the attorney's fees are actually allocated to the law firms. My point is, though, that thing he created, which upset some folks who think you need a rule that permits you to do exactly what the rule permits you to do. And as I think Sheila said, he viewed the law as dynamic, and he was creative, and he did things with federal rules nobody else really thought of doing, and he did things with the law, and he stretched it and molded it until he got it exactly in a way that fit the situation. But since his creation of the quasi-class, even though it upsets some, many judges have followed suit. I can tell you in Vioxx and a number of cases that followed after this. And we're at a point now where judges who have really employed these principles to controlling attorneys' fees and loosely overseeing settlements, not having, because they're not required to approve them if it's not a class action, have adopted his way of thinking from his Zyprexa opinion. And they don't even really mention, I mean, for years, the quasi-class was mentioned in these subsequent opinions. Now it's just accepted that you can do this in an MDL. And I want to just circle back one more personal note, besides trying to express as a lawyer how exciting it was to be with him, how to hear his creative mind, to express concerns and then work through solutions. But I'm one of the, I was really disappointed on this panel to find out that letter he wrote me at the end of the case, telling me that I did such a highly professional job, that I'm not the only person that got one of those. It's a little disappointing, but because it's framed and it's up on my wall. But one last thing, and I don't know if anybody's mentioned this. One other thing I was blown away by Judge Weinstein is when I would walk into his court, inevitably we'd be following like a sentencing or some criminal matter. And I was blown away the way he did sentencings. And as anybody that knows him knows this, but he would sit down at counsel table with the defendant who he was about to sentence, or he was having some hearing about sentencing him. And the first thing that he would say to them is, "How are you today? Are you being treated well? Are you eating okay? Are the marshals treating you nicely? Is there anything you want to tell me before we get started?" And I tell that story today to judges around the country, and everybody who hears that, if they don't already know about that, are just blown away by who he was, his style. And anyway, those are my quick stories about the judge, and I'm going to miss him. I still think he's a rock star. I think we all do. But thanks, Sam.
Thanks, Chris. John?
Thanks, Sam. And thank you to David Sifford and the Center on Civil Justice for organizing this wonderful event. I'm honored to be a member of this remarkable group of people and to have a chance to say a few words about Judge Weinstein. For starters, I should mention that, like everyone else here, while I aspire to objectivity in my remarks, I am unlikely to attain it, as is the case with others. Judge Weinstein played an outsized role in my professional and personal life. Not only did he make the mistake, I guess, of employing me as a law clerk and serving as a mentor to me for my entire professional career, he also officiated at my wedding. So for me, he will always set an unattainable standard of professionalism, the embodiment in law of learning, wisdom, dedication, determination, energy, creativity, cleverness, and compassion. Like Judge Gleeson and my former professor, Burt Neuborne, I have jealously hoarded my stash of scrawled JBW notes. Okay, so I will consider, as the panel, in keeping with the panel topic, an aspect of the judge's work in complex litigation, and particularly mass torts. As has been mentioned, starting with the Agent Orange litigation and even before, Judge Weinstein pretty much invented this field. His contributions are so vast that we could talk about them for days. I'm going to confine my attention to his distinctive conception of the role of the trial judge in mass tort litigation. And as it turns out, I'm mainly just going to be amplifying a point already made more concisely by Elizabeth in her comments. It was not so long ago that our legal system contained two different kinds of courts, courts of law and courts of equity, each with different jurisdictions and powers. Although the law and equity courts were fused around the turn of the 20th century, Judge Weinstein clearly believed that a version of the distinction between them survived. As he saw it, law is the realm of ordinary dispute resolution. A trial judge faced with a garden variety breach of contract or employment discrimination or tort suit adjudicates the case by applying rules of law to determine whether the claimant prevails, and if so, the remedies to which she is entitled. Equity, by contrast, is the realm in which judges exercise extraordinary powers to handle types of disputes that ordinary law purports to be able to handle, but cannot. Accordingly, courts sitting in equity enjoy more flexibility when it comes to the procedural, substantive, and remedial dimensions of litigation. Provocatively, Judge Weinstein insisted that mass torts, instances in which thousands of claimants allege injuries caused by the actions of large firms, industries, or government actors, fall within trial court's equitable jurisdiction. They do so, he thought, precisely because the rules applicable to ordinary law cases just can't handle these mass torts. Traditional legal rules, both procedural and substantive, are designed to resolve disputes arising out of individual interactions. Smith, claiming to have been injured by Jones, hires a lawyer to bring a lawsuit against Jones. The job for a law court is to determine if Jones really did injure Smith and in a way that renders Jones legally responsible to Smith. Mass torts, of course, involve claims by thousands of Smiths. Often these Smiths are represented en masse by a handful of lawyers, and it is impractical to have their cases resolved in the courts one by one. In addition, suits by members of a large group who claim all to have been wrongfully injured in roughly the same way lend themselves to a less deterministic, more probabilistic approach to causation, which for torts is central to determinations of responsibility. A single veteran unable to prove that his particular cancer was caused by exposure to Agent Orange will lose his lawsuit against the defendant manufacturer. By contrast, evidence of a statistically higher incidence of certain cancers in Vietnam veterans might suffice to establish grounds for a court of equity to provide them some relief. Notably, any remedy provided would reflect the shift from deterministic to probabilistic assessments of causation, whereas an individual claimant who can prove causation and other applicable tort elements in a standard law case is entitled to make whole compensation. A class of claimants who can show only a possible statistical correlation might stand to receive substantially more modest payments, perhaps along with the provision of in-kind assistance, such as access to counseling or other court-provided support services. Judge Weinstein's insistence that mass tort cases permit the exercise by federal trial judges of a special set of equitable powers was in many ways a boon to claimants. Countless individuals who otherwise had little chance of pursuing their claims benefited from his flexibility in aggregating and processing claims and in fashioning novel remedies. In this very basic sense, Judge Weinstein's equitable approach was meant to be and was friendly to little guys seeking to hold corporate behemoths or government leviathans to account. At the same time, as I have noted, equity in the hands of Judge Weinstein was hardly nirvana for claimants. Famously, as Sheila noted, the settlements that came out of his application of equitable principles often resulted in relatively modest compensatory payments, payments that many recipients regarded as woefully inadequate. Others were denied relief entirely. The doing of equity in Judge Weinstein's hands was not the attainment of an ideal of distributive justice. It was seeing to it that victims of injustice were acknowledged as such, were heard, and were provided with modest assistance that might help them recover and improve their lot. Unsurprisingly, given its distinctiveness, Judge Weinstein's equitable approach to mass torts has been questioned, usually by critics too prone, in my opinion, to invoke the unhelpful epithet of judicial activism. In trying to gauge the extent to which these charges should be credited, two comparisons might be helpful. The first compares Judge Weinstein's judicial performance to that of other judges. The second compares his approach to mass torts to other approaches. While Judge Weinstein often gets singled out for his activism, I think it's pretty easy to find other federal judges who push or have pushed in comparable ways on the limits of judicial authority. Indeed, I would suggest that even some federal judges most strongly associated with judicial restraint, including, for example, Justice Scalia in a number of important federal preemption decisions that Sam has written about, has been adventurous as Judge Weinstein in inserting an inherent power to address the challenges posed by tort claims. As for the best way to handle mass torts, the alternative to Judge Weinstein's judicially centered equitable approach, one that arguably now predominates, is a more or less privatized scheme in which plaintiffs' lawyers jockey among themselves and with defense lawyers to craft a settlement on terms that they find satisfactory. The courthouse on this model basically exists to provide a locus for this complicated business transaction, and the trial judge is there primarily to bless whatever the lawyers come up with. An obvious worry about this model is that it countenances bargaining outside the shadow of the law, and indeed bargaining outside the shadow of equity. Others are better equipped than I am to assess its costs and benefits, but it is far from obvious to me that the privatized approach is superior to the version of equity administered by Judge Weinstein. Let me sum up. Equity sounds attractive and simple. Look, just do the right thing. It's not. Anyone who has witnessed or studied Judge Weinstein's handling of mass tort cases know how much time, thought, effort, strength, and judgment were required to resolve them on tolerably fair terms. Indeed, perhaps the biggest flaw of Judge Weinstein's equity model is that its proper operation might well require Judge Weinstein to be on the bench presiding over the case. The US can proudly boast of many great jurists, past and present, but there was only one Jack Weinstein. Thank you.
Thanks, John. That was really very elegant. Adam, you want to wrap up? Before you do, the code for those who need it one more time is CCJW3. Please use that for your CLE, CCJW3. Adam?
Thanks, Sam, and to Peter and David and all the others at the Center for Civil Justice for inviting me. There's no way I can really do Judge Weinstein's contribution to complex litigation justice, but I'm really glad to be here to say a few words about him. I'll talk about three ideas that animated how the judge approached mass torts and about his expansive view of complex litigation that I think we'll be grappling with for decades. The three ideas that animated how the judge approached mass torts can be boiled down to, first, a belief that courts play a unique role in our separation of powers to hear from people and respond to them. Unlike the other branches of government, the executive and legislative branch, which might or might not respond to how society or individuals petition them, courts were uniquely obligated to listen to people, to decide how to respond, and give a justification for what they did. The second idea that animated Judge Weinstein's view of complex litigation was this expansive approach to procedure and civil justice, what procedure is and who it can and should serve in courts and beyond. And he matched that belief in what courts can do with a talent for managing people, dealing with people, and an incredible attention to how details matter for serving justice. And the third, which I want to spend a little time talking about, is his unparalleled ability to see patterns and commonalities across so many different areas of law that were often siloed off from one another. He saw different forms of mass litigation in all different kinds of places, whether they were civil rights cases or toxic tort cases, inflated ratepayer, antitrust, even some criminal cases presenting the same set of concerns for courts, whether they're brought as class actions or informally aggregated by law firms or insurance or other organizations. He thought that claims brought by on behalf of a large group of people threatened those first two values, that of hearing cases and administering justice, unless we were willing to at least question that old bipolar one-on-one horse and buggy approach to those cases. Those cases were inevitably going to be handled en masse by someone, thereby jeopardizing how we typically balance individual and mass justice. And given the thousands of cases involving the same dispute, there was no prospect they all could be tried. And as the judge used to say, if justice delayed is justice denied, justice hastened is justice served. And so the principal question Judge Weinstein asked of us is how and in what ways courts should go about doing that. And it's that final idea that arrogation of some claims was structural or inevitable across all these different areas of law that I wanted to spend like 2 minutes on. It's what led the judge to expand the use of class actions to mass torts. It's how the judge came to see other forms of arrogation, like the ones Chris Seeger talked about, like MDLs, raising many of the same types of questions as class actions. And finally, how problems of mass torts extended outside of the courts to other institutions that provide mass compensation, like state AGs and federal agencies and prosecutors that sometimes sanction people and institutions and take that money and use it to compensate large groups of people. So first, Judge Weinstein expanded the use of class actions and the public law model of judging mass tort cases. And in thinking about like how he came to apply class actions to solving mass torts, it's important to remember that Judge Weinstein was the last living jurist who worked on the Brown v. Board litigation. The Brown v. Board litigation produced amazing jurists: Thurgood Marshall, Constance Baker Motley, Spotwood Robinson, Robert Carter, and Judge Weinstein is the last living member of that jurist who was on that team. And when the 1966 amendments to Rule 23 came into play, they were designed largely to work in civil rights litigation, and they even cited a young Judge Weinstein, 1958, I think it was a Buffalo Law Review article, where he said, the one area where we might question the use of class actions was for mass accident types of cases. Needless to say, the judge's view on that issue evolved. And it evolved in part because he, reflecting on his own work in Brown and the voting rights cases in New York, which he traveled around New York State to deal with, and the supervision of the Mark Twain Junior High segregation litigation that I think Burt was talking about in Brooklyn, he came to see mass tort litigation as raising some of the same concerns as other forms of institutional reform. And he even came to say, like, mass tort litigation is public interest litigation. And that public law model of litigation, which was famously associated with Abe Chase, and which he kind of structured this very famous 1994 Northwestern Law Review after, was a really important idea for the judge, because they required more than just appreciation of the cases that were in front of him, but the community and the thousands of others that were outside the courthouse door. And he used the same techniques. That was the idea, the same techniques to resolve them, the same active case management orders, special masters, fairness hearings, supervised structural relief after a settlement to do so. And in that article, he said, he justified it by appealing to that public law model idea that was associated with class actions and institutional reform. He said, a rigid and unresponsive judiciary, blind to the needs of various communities and societies at large, is far more likely to cause an erosion of public confidence in legal institutions than a judiciary perceived as overly interested in resolving the problem before. So other people, as others have mentioned, came to criticize the judge for this view. Institutional reform doesn't involve money, it's structural relief. Doesn't involve the same rivalries for fees and financing. Not all mass torts involve like the same type of community-like concerns that you might see in structural relief litigation. And the cases involve different types of substantive issues that sometimes might require more individuation. But whatever one's critique of the judge's solution, his description and critique of the world of mass torts before him, that it couldn't be solved in the same old way in one-on-one litigation, that it required some other deeper exploration of the procedure, substantive, and ethical values behind it, was something that we're all dealing with and will continue to deal with. The second, and related, is Judge Weinstein's view that other forms of mass consolidations raise similar issues as class actions. And Judge, people are still writing about this today, about MDLs, but Judge Weinstein was one of the first writing in the early 1990s about how MDLs were, as Chris Seeger was saying, a kind of quasi-class action. That phrase that he used in Zyprexa dates all the way back to an article he wrote in 1993, 1994. And he wrote, obligations to claimants, defendants, and the public remain much the same, whether the cases are gathered together by bankruptcy proceedings, class actions, national or local consolidations. The judge's functional view of mass litigation allowed him to see arrogation in many different places. And I think that analysis is reflected in the ALI project that Sam was describing. And so even though MDLs were technically only supposed to consolidate cases before trial, he saw they presented the same problems. They required the same type of judicial management. They required a similar role for the management cases, appointment of special master, supervision of fairness of settlements, of fees. And people have criticized Judge Weinstein for this view as well. It's active, it's lawless, but his critique about how those cases were organized, how they departed from the one-on-one model, those are timeless. And even as they critiqued the Judge Weinstein's philosophy behind why he should intervene, that it was a form of public litigation or should reflect a more communitarian ethic. The new models today to try to deal with MDL litigation still reflect the contributions that he's made, whether it's hub and spoke or letting lawyers be lawyers. They take for granted his solutions of CMOs, special masters, steering committee appointments that remain the staple of the manual for complex litigation. The last thing I want to talk about the judge's vision, his ability to see commonalities in mass litigation, is how he came to see how other institutions, whether they're federal agencies or prosecutors, even presidential administrations, serve the same types of goals sometimes as mass tort litigation. As I said before, sometimes an agency can sanction institutions like the FTC or the SEC, and then take those proceeds and compensate large groups of people. And sometimes they might rely on the same type of case management. And in many cases, those facilities were also overseen by Ken Feinberg, who was speaking earlier. And he saw these institutions as kind of playing a similar role as like the class action. He describes this in a 2001 Law Review article in Illinois. He still thought the class action remained necessary to serve those earlier goals that I mentioned, to kind of serve justice from the bottom up, to listen to people and respond to them. But he also saw that those competing institutions presented a unique problem for the federal courts, that if mass tort litigation represented a form of public interest litigation, who has the best claim to the public interest? How is a court to balance the interests of like civil and administrative and criminal justice in a mass litigation? Which of those institutions can provide global peace, if ever? And that phenomenon describes some of the biggest mass torts we have today on the scene, whether it's opioids or the mortgage foreclosure cases or vaping or climate change litigation. It's this question: how does the judge balance these different parties and interests of the states, the cities, the tribes, the regulators, the private plaintiffs, all having claims to private compensation of the public interest? And it was Judge Weinstein's vision, that compassion, that ability to see across different boundaries, that raised new questions and problems that the field will continue to grapple with for years to come. I guess I should say one last thing. I was trying not to say anything personal because, unlike almost everyone else, I think I'm the most prone to break down. But when I clerked for Judge Weinstein, I clerked for him in a tough year. I clerked for him over September 11th. He lost a number of dear friends that year: the late Charlie Black, Hal Korn, his colleague at Columbia, who helped him revise the New York civil practice rules, passed away, and whom he, along with Arthur Miller, is on the New York CPLR treatise and a criminal law treatise. And the judge always was ready with, just like he was sending out letters, a more morbid thing that he would do, but this reflected how mensch he was. He was always ready with letters and op-eds and ready for the New York Times to kind of send out his summary of a person's life. And so he wrote up a review of Hal Korn and all the things that they essentially did together. And he sends it to his wife, Evelyn, and Evelyn sends it back to him, and she says, there's just too much of you in this. There's just too much of you. And he took that as a critique, and he went back and just like interviewed a bunch of people. And if you read that immemorial article in the Columbia Law Review from 2001, you'll see it's actually a little distant. But I always took that statement, there's too much of you in there, Jack, as an incredible compliment, because I think that we all can say that about Jack Weinstein and his influence and impact on us. When he passed, all I could say over and over again is how much I owe my entire career to him, my clerkship with him, my work with Ken Feinberg, all of the things I've written about. It just will, and as well as all of us, will just owe so much to his incredible legacy.
Thank you very much, Adam. This brings us to the end of the program. I hope that nobody will be offended by us having taken the liberty, being the Center on Civil Justice, to focus on one aspect of Jack's extraordinary career, which was his impact on the world of complex litigation and mass torts and so forth. But from my many discussions with him over the years, I don't think he would have been offended. I think he saw this as one of the high points of the problem solving in the real world that judges had to engage in, had to get their hands dirty with. He was a master, and I'd like to thank the panel for this wonderful presentation and tribute to Jack.
So before we close, let me just ask whether any of our panelists have anything further they want to say, or David or Sheila is on. I see Sheila is on. Do you have anything further you want to say, or no? Okay, I just wanted to end by saying thank you to the moderators and to the panel members for presentations that were at the same time stimulating, insightful, and as I said, at the same time, so beautifully heartfelt. That's a hard thing to do, and you folks did it. So thank you. David, do you have any instructions that you have to give about the CLE?
Just a reminder that the form will be sent out at some point tomorrow, and you'll need to include the 2 codes that were read out and return those forms to us. And it may take several weeks to get your certificate sent, but we will send them to you.
Okay, well, thank you, everybody, and have a good rest of the day. Bye-bye.
Thank you. Bye.
Thank you.